Hi, everyone. Welcome to Stella and Amy's podcast. This is Amy.
Hi, this is Stella.
Today, we have a special guest all the way from Virginia. His name is Gilles. Gilles is a patent agent who helps innovators protect their ideas. He specializes in AI, software, blockchain, and healthcare technologies. Today, we're going to learn a lot about patent. He worked on both inside and outside of USPTO, which is U.S. Patent and Trademark Office. He worked at USPTO for 10 years as a patent examiner and then went on to law firms to help companies with patent.
Hello, everyone. My name is Gilles Kepnang, and I'm a proponent of innovation. I'm a patent agent with a focus on AI inventions, and that is my specialty. It's great to be here with all of you. Looking forward to talking about what's on the horizon and good news coming ahead.
Much better introduction than me. First of all, what is a patent? Why does it matter? Because me and Stella, we are engineers. We don't encounter the idea of patent every day. Can you tell us more about what is a patent? It's sort of abstract to us.
Yeah. There were a couple of times where the company asked me to patent something, and my reaction was always like, oh, do I have to do this? So educate us, Joe.
Sure. It's interesting that you get that request and you think in that way. This is how a lot of engineers and technologists see the patent. It's just another document, another process. The definition for a patent is the rights conferred by the country's government for the inventor, the person who created or discovered that idea. So it's a right. The idea itself is not a patent. The product is not a patent. It's the right that's assigned once they realize that person is the original person who created it. And now you wonder why does it matter? So why do we care?
Yep.
One aspect of a patent, it's actually an asset, but it's an intangible one. So let's take a comparison. A house is a tangible asset. Land is a tangible asset. A patent is intangible. It's a right that gives leverage for a person to do many, many things with it, depending on what their business is. So that's why it matters. Whoever has the patent has more options about what they want to do with their business.
I also had the experience when my company asked us to patent our algorithm, our machine learning system. And when I first got the request, my reaction was, oh, can we even make money out of this? Why is this so much work? And before we finish the patent work, we've already moved on to another new thing because the technology evolves so fast.
Exactly.
How do you react to engineers like me?
Okay, so I will tell you to make a roadmap because it's always tricky. You have the product that's running, and then now you're making an improvement on it. So it's becoming better.
Yeah.
I would tell you to make a roadmap first, where you see the product going, and then after make a patent where you cover as much of that roadmap as possible. So now as you continue to improve, you can add more of those features, but the patent is already secured because all those features are on they will be in the product anyway.
Nowadays, a lot of AI innovations are happening. We can see new models coming out every other day. Do you have a lot more work now? I assume these AI companies will want to make a lot of patents to protect their algorithm, their AI innovations. Do you see a lot of demand in that space?
So I definitely do. But what's happening now, they're coming with the ideas. When they come to me, they tell me they have the idea and they have the prototype. But then I ask, okay, so what's the problem? What's the solution? And that's actually very difficult for them to explain. The idea is there, the features are there, what they want to do is possible. But that first question of problem and solution, that tends to be the challenge between whether we'll take them on for business or give them more time to flesh out their details before we start. So there's definitely more work. If you're asking in general, there's more work from startup companies.
Let me try to put myself in your client's shoes. If I have a new AI model, say I have a new model that's better than GPT-5, and I want to patent that, and I come to you, Gilles, you ask me what's the problem and solution. I'm gonna say this is the solution to everything. It's such a powerful model, and it's such a innovative invention. What do you mean I have to define the problem and solution? And I guess maybe this resonates with you. A lot of clients might have that kind of reaction because
everybody's invested. Everybody does have the best solution, the best thing since sliced bread. And I enjoy that enthusiasm. I actually think that's what makes this job very important because the inventor is enthusiastic about what they've created. You're enthusiastic about the solution that you're bringing to us. What I now do, I research you. I research your background. I research the work that you've done before, the projects you've been on, and now the solution that you're focused on. what is it really about based on who you are, your inventor profile, your personal profile. So it's great that as an inventor, you bring that enthusiasm, because from there, it's easier now for me to do the groundwork, understand your invention based on the work you've done and also the field that you're in. And from there, it's also easier for me to show you what opportunities you have for intellectual property.
Another question I have is whether a product or a model we build is patentable, because many things, products or projects that we build are built on top of many open source softwares or many open source libraries. Is there a scenario where if my product is built solely on open source and that could make it unpatentable? Have you seen like any examples like that?
I've discussed about those examples with partners, and this is partners from different firms, some of them in California too. This includes the Apples, the Googles, Counsel, who is at a lot of the FANG companies. And what happens there, the open source has a license usually. The functionality that's performed by that open source, whether it's a library or whichever component, it does not have coverage for the patent right. So the invention itself can work, but when mentioning the functionality of the open source, one or two things happens. There's a discussion with the open source licensor about whether it's something they can let go, if they can. And if they can't, then the claim coverage for the invention, because every time a patent is established, is based on the claims of the invention. The claims will exclude the functionality from the open source license. The reason why they do so is because if this goes to litigation later, let's say there's an issue where we have infringements, those kind of situations, the product that has that open source functionality tends to be more at risk than the one that doesn't have the open source. So with open source, if you can make an agreement with the owner of the open source license, it's better. But usually they want to keep it public for everyone. It would take a special interest.
When you mention the owner of the open source, that's already very hard, because usually an open source project doesn't have one owner. So how do you find the person to actually decide the fate of this project is also very tricky, right?
It is. Again, you have the full community, and now finding the specific author and the person who's maintaining the community. Yes, it does get tricky. For those situations, the patent engineering teams, they tend to avoid placing code that's been used from open source in the solution, and they tend to avoid mentioning it when drafting for their patent.
You have a difficult job, Gilles. It's not just tracking down all those open source libraries are challenging, but also there's this ideology of everything should be open source in this software or technology community. So for example, like I'll take myself as an example. When company asked me to patent a project that I built, I didn't want to do it partly because I know there was going to be a lot of paperwork that I need to fill out. But on the other side, I was like, I just want it to be open source. How would you respond to clients like me?
So in a situation like that, you have the product. You're considering having the entire product being open source.
Yeah, so let's say it's a model. So maybe like a full-fledged product.
All right. So you have a model now which you want to make open source. At that point, we're not talking about a patent anymore. We're talking about a license.
Okay.
We're talking about a license for your model. It's the same process as you would for any other software, any other software system. The difference here is the ownership of the data, because it's the data that was used to train the model. So there will be ownership here on the data that was used to train the model, and also ownership on the model itself. And any output that was used to affect the change in the system, but you wouldn't be able to get a patent on it because you've now made it open source. Within the patent world, when there's a claim to a general solution that everybody starts to use, the owner can actually license and sell licenses for that patent. But here's the difference with open source. If it's open source, it's free for others to use, it's free for others to build upon. So in that case, there's no patent negotiation, there's only licensing.
What does licensing entail here? Because for engineers, we all worked with GitHub. There's always this like default license template that GitHub offers, or actually multiple different license templates that GitHub offer. What are the differences between a canned license from GitHub and say a license that you just described, Gilles?
Okay, so before we get into talking about license, here's where we'll get into the legal parts. I want to make a disclosure. The views presented here are my own. They're not the views of my firm, and they do not constitute as legal advice. So what I will say here about licenses is to make the difference. It won't be advice for what anybody should do when they're looking to get their license. The license for GitHub, it's declared there's a contract, and there's a contract that shows that this license is formed by GitHub, and again, recognition goes to GitHub for that license. If anybody else creates their own license, they're creating it knowing that they're going to be having the ownership. So they're going to become like a GitHub. The template that they're using, it will be tied to their entity here, their company entity. Whether it's their LLC, their incorporated, their S Corp, that license will be tied to that particular company entity. And the contract, usually with a team of good lawyers that have experience on licenses, they can create the contract based on what the client wants. So like we were saying earlier, if you are the client, we'll be looking at, okay, what is your long-term vision for this open source product? How do you want people to use it? How do you want them to access the data? Is there other data that they can use to build on what you've done with your model? So maybe performing the same steps that you used to create your model, but can they use other data? These are the kind of questions that the team will be asking you to make sure that they make your contract stable for your license. When the license is established, it will be established based on client so-and-so's company entity name.
I think because we mostly work with open source project and it's mostly MIT and Apache. For us, we don't understand all the intricacy around actually making money from the licenses. Our default is to not make any money or pay any money to use the license.
Yeah, like to me, the MIT license and the Apache license, I'll admit that I never read the details. But to me, if I see that license or those licenses, what they say to me is like, you can just use it for free.
Yeah. And to Stella's original question was, she doesn't have an incentive to license or patent her technologies. Because when licensing event can happen or when the company can make money out of it, she doesn't make any money out of it.
That's true. It's not me making money out of it.
I guess that's the main point. So when you are just an engineer working under a company, the company wants to patent something, there's really no incentive. And our incentive is more, our liking is more to share, because when the company makes money, we don't get a share of it anyway.
And so there is a trade-off, right? Because when you're sharing, now the entire developer community has more to use, and they could also recognize you. So you get some. So it's like getting the fame.
Actually get more.
Right.
It's the question of the money versus the fame. The money comes when you have a product that you've again built brick by brick, and again just developed it into a solid concrete product that you can present to the people and provide to the public. When it comes to startups, those who have their product, and then let's say they have a patent that they have behind the product, it's easier for them to launch because now they have a stronger signal to the public. When you have an open source and you're providing it to the developer community, it makes you as a developer more well-known. It makes you as the engineer more well-known. It can also build the momentum for a product that you may eventually want to build up. It's a strategy.
Yeah. The trade-off here sounds to me is whether it's the benefits for the company or if it's the benefit for the developers.
And sometimes it might have to be a win-win for a while. The company benefiting from the product, and then you as the engineer or technologist benefiting from the recognition on it. And then as time goes on, more people know your name, you have more visibility. By the time you do launch a product that is yours, now everybody can be more interested in it because they already know about the contributions you made in the past.
I do see a lot of this hybrid strategy being more valuable long term. You establish yourself at a very low cost. It's free marketing for the developer. And then later on, you leverage that and build more products and you have the fame. Yeah.
I know a CEO named Martin Heron, H-R-O-N, last name. He's a CEO for a cybersecurity company. But before that, there were plenty of open source contributions that he made before building out the company. So by the time I introduced myself to him, and this is back in 2020, he was like a rock star in the cybersecurity world. So it makes those conversations easier. It also, it's very much like the music industry. Knowing the music that somebody puts out for 3, 4, 5 years, by the time they come out with an EP or major album, now everybody is ready for that artwork. In a way, what engineers and technologists do, there's a craft to it. And being recognized for the craft is it's an investment for the long term.
Yeah, need to be altruistic first.
Let's see. So altruism is appreciated. Let's put it this way: it's good for the long term, but there's no time limit on when to make value. with the right investors and right backing.
Jill, let me ask you this question because Stella and I are open source proponent, but I'm trying to think in a different way. If I want to be intentional about my invention in AI and I want to invent something and then I want to protect myself and patent it eventually and make money, how should I go about this project differently compared to open source project?
Ask the question a different way, please.
Yeah. How do I make money with my patent?
Okay.
Yeah, before I even start building anything, how do I intentionally make this a profitable project with patents?
So plenty of ways. The first way, finding investors. Having the patent, it gives you an asset that you can go to the investor with, and it shows them. So it gives the client an asset that they can present to inventors, and it shows the inventors that the client means business. So in this situation, if you have a patent, you can make it available. It's public. Anybody can access it. Go on Google Patents. They can look up the number and see exactly what that product does or solution does. You can also license it, and you can license it for a cost. You also have the passive benefit of people trying to infringe on you. And those who do infringe, you can take them to court and actually make more benefit if it's proved that you're the original owner. And then you can also have it available for sale to a larger corporation if that's the route that you want to go. So take any big tech company. If you have a solution that they could use and they could also leverage, they would want to buy that patent from you. If you have many companies who are interested in that patent, now you can have a bidding war. So the right itself, it gives a lot of leverage, and actually it gives a value that you can assign based on what you know about the market and based on what you're looking to pull in from the market.
Can you share any example of like a bidding war on a specific patent in a technology space?
I don't have one off the top of my head right away, but I think in the augmented reality space, there was something that happened with BMW.
Oh, BMW,
They have some
the automotive company?
The automotive company. They have these augmented reality display spaces that they put on their windshield. And there was a feature that they wanted to put, I believe it was for the speedometer, the way the speedometer is designed. And then they also wanted to be able to put the Google CarPlay or the Apple CarPlay. There was another company who made that feature.
Oh, okay.
So there were a bunch of automobile companies looking to get that, and that caused a bidding war. But that bidding war specifically was for a design patent, not a utility patent. Another thing about a patent too, here in the United States, we have 3 different types of patents: design patents, utility patents, and plant patents. Now, the plant one is very unique.
It's the actual plant.
It's an actual plant that's created. The utility patent is a patent that's useful. It has a product, a method, or article of manufacture that is useful to the industry. A design patent is a concept. So, for example, let's take the augmented reality. The way the display is put, it came from a creator. It came from an artist. That kind of creation, if anybody else copies it, there's a patent on it too. It's separate from a trademark. It's an actual design that is used as a product. So that's why it's a patent. And then the third one is a plant patent. Easy to say, it's a plant. But again, those are very rare. I think I was at the United States Patent and Trademark Office for 10 years. And not one time did I come across a plant patent.
Oh,
They were there.
Pattern as
a plant.
Unique plant.
Okay.
A new type of plant.
Wow.
Exactly.
But when you talk about the design pattern, because as a user, of course, we're going to try to put the CarPlay on augmented reality dashboard on a car. But if you took the effort to patent it, then everybody needs to buy it from you.
Exactly. In that specific way.
So is it, if we put this into the software engineering context, the design pattern, is it more like the UI UX design, and that can be a design pattern, but the actual product, a product that is usable, will be relevant to a utility patent? Is that how it works?
Exactly.
Oh,
so
okay.
When you have the user interface, what's being presented and what the user interacts with. So there are listeners on the user interface. Those listener functions that later on cause certain services to be called, those are utility patents. But the design itself of the user interface, where elements are placed and why they make for a better design, better user experience, that is a design patent. So the design patent is for UX benefit. The utility patent is for practical functional benefit. It's great that we're talking about that because a lot of people don't know about that separation. It was the lawsuit between Apple and Samsung. This was a good while back. It all focused on those particular designs. I think that lawsuit came out to about 10 million or something like that.
Those are mostly design patterns, right?
For that situation, it was the design patent, yes.
Yeah. How you design the phone itself and then a lot of UX small details. I remember they had a lot of dispute over that.
Those are the design patterns that I can make sense of. But for the BMW one, because I once owned a BMW, I have used that feature. I'm actually surprised there was a bidding war over it because it was just okay.
There are some features where, as a user, you use it and you wonder, okay, really, was it worth having the bidding war over this?
Yeah, exactly.
But for the companies and their vision, sometimes it'll be a war of attrition and it's happening in the background. It doesn't come out to make
Headlines.
It doesn't come out to make headlines. But starting to win those little wars in the background, that's what they now use when they want to later on make much more improved experiences.
That makes
For
sense.
example, recently they came out with a conversational AI. I believe BMW did. So it's like the movie Knight Rider. You have like there's an entity that actually talks to you while you're in the car now for the BMW. I don't know they have a patent on it yet, but they're previewing the feature.
Is the conversational AI special in its software, like how it works? How does the chatbot works? Or is it more about the interface?
It's the model.
Oh, it's the model.
So the model and also how it's improving its conversation with the person it's speaking to. What makes AI tricky is you have a system that's designed. You can look at the way the system is designed and say, okay, well, two human beings could speak this way. But with conversational AI, the way a machine can adjust its voice, adjust its utterance, adjust its tone, even request how you like to converse with it. This is what makes conversational AI more evolved than just human engagement and human conversation. Because every human is their intrinsic person, they are their personality, they speak how they speak. But with conversational AI, you can change the voices, you can change the tone, you can change the cadence, you can change the experience that you have and the context that questions are answered to you with.
Speaking of conversational AI, I know you work on a lot of patent work in the AI space now. What are the most popular patent categories now? Like utilities, design, are there specific models? What kind of patents are you working with in AI now?
These days, autonomous vehicles.
Oh, really? So are they more design patents or utility patents?
All utility.
Oh,
Or
utility.
Design would actually be easier because with design, it's easy to see the design and tell if it's unique. Utility it's a bit more difficult because you have to look at the functionality. So what AI model is being used? What system does it reside in? Example, we take an autonomous vehicle. If you have the sensor technology, you have the AI model, which is being downloaded to a vehicle from the cloud, hypothetically. So just taking hypotheticals here. The sensor information is being received by the car from the external environment. Again, this is just an example. And then the server, it has the AI model, which can either be processing the information from the car or using a downloaded model into the car so the car can make decisions about how to navigate. How these systems are built, it's now becoming more improved.
So most patents are these system architecture or specific parts of the system?
There's more focus on system architecture. And actually, there's a special reason why. Lately, when it comes to how patentable AI inventions are, it's difficult to tell whether AI invention is patentable. There's been a lot of discussion about that over the last 6 years. In 2019, they came out with an eligibility guidance, and they wanted to make a separation between what an AI does and what human activity is performed, mental process, or mathematical calculation, to compare and see if it can even be patented. So let's say you have a AI system that says 1 + 1 = 2. That's all it does. Technically, I could calculate 1 + 1 = 2 because in my human mind, I can do that. So if an AI only does 1 + 1, if that's all it does, calculate 1 + 1 = 2, it's not patentable because it's a mathematical calculation. An AI system would need to do more than just a mathematical calculation. It would need to give a solution that can be applied in a particular industry.
What about prompting? Say if I have a brilliant prompt that I designed that is used on top of an open source model and it does a certain task very well. Is that something patentable?
The prompt itself would not be patentable because it's a string of words. When it's used by the open source model, okay, now it depends. Yeah. So the open source model is going to give an output. At that point, the prompt itself was what caused this entire invention. So the prompt is not enough.
Okay.
The prompt itself, it would be considered a method of organized human activity because when you give the prompt, it's a command that's going to output and generate something based on it. Just the command to generate something, it looks like a human interaction. If you were to claim generating this prompt, it would be difficult to make coverage for it because, for example, when you look at a patent claim, it shows functionality. So the claim would be, we generate a prompt with a string of letters, we provide the prompt to a model, and output by the model a certain result. That kind of process is not enough to show an invention.
What if my claim looks like this? I generated a prompt, put it into X model, and then Y output comes out, and it's useful to do agriculture in a certain way. And that improved efficiency of some agricultural activity by X%. Is that patentable, that this whole set of actions?
The entire set of actions now becomes patentable, yes, because the output was being used to improve something in agriculture. But again, with these systems, the model has an input, the model gives an output, and then based on the output, it makes an effective change in a certain environment. That change that it makes is the result and the importance of the AI. And that's the part that makes the invention, the change that it actually made effective. It's one of the tricky parts about working with AI now, because since 2019, there have been decisions made where they said, okay, claim language for AI. Right now, it still looks very much like math. It still looks very much like calculation. It still looks very much like what a human can do. And then recently, just last week, the USPTO put a new director, John Squires. He looked over this interesting AI invention. There was a model that updated the parameters based on the first task it was assigned. It saved those parameters in memory. That same model received the second task and adjusted the first parameters for the second task in memory again. The same memory location. Before, they looked at it and said it was an abstract idea because all they were doing was adjusting the parameters. But the real benefit was that they saved those parameters in the same memory location, which reduces the storage. Because usually each task, the parameters are stored in separate memory storage places. When you're using a cloud services, you see this. Now that you have them all stored in one place, it's centralized. It also reduces more resource consumption.
So if he gets the patent, does it mean like other engineers cannot just save the updated parameter in the same location anymore without infringement?
That's right. So if anybody else looks to update the parameters and save in the same location, now they're infringing on the patent. Because it was unique.
Stella feels uncomfortable.
I feel very uncomfortable.
Wait, why so? What's concerning you? What's concerning you?
I feel uncomfortable that because to me, yes, this is a smart design, but the fact that future engineers will have to pay this person in order to save parameters in the same location in memory, that just makes me very uncomfortable. I also feel uncomfortable because this person or this company was the first one to patent it. But I feel like there must be someone who have done it in the past, or many people have done it in the past.
Now the thing about it, they never tried to apply for a patent, so it's fine.
Because again, we are all for open source.
We're not smart enough.
Open source, it is the way of the future. We look at all the platforms that are there. The community of technologists, engineers is growing. The world of open source, I think there's going to be a lot of opportunity for licensing too, especially for startups. So the same way we have more opportunities for patents, there's going to be more opportunities for open source licensing. And I do want to ask a question before I speak more on this. What are the benefits that you see from open source right now compared to patent applications?
Transparency, and everyone gets to build something on top of what others have built. So it helps with innovation. Okay,
makes sense. I want to look at what's happening with AI and say that there's a transition now where we're going into this new revolution. The real purpose of AI is to help people leverage simple tasks so that they can return to doing other things that are important to them in their lives. But as far as overall development, as far as implementations, new systems that are going to be built, it is still always going to be humans building these systems and humans exchanging information about these systems. The data that's being used for artificial intelligence and those implementations, they cannot be leveraged from the open source community. And that's why they've made a hard boundary between what can be made patentable and what is available for disclosure to the public. They do want to continue fostering that spirit of technology. And really looking at most large language models now and what they generate as far as code examples, a lot of time is maybe 50 to 60% accurate. We look at the tools, again, what's it called? Vibe coding, and again, just all these other tools.
Yep.
They're great for fundamentals, great for learning how to code, great for making quick solutions, but real sustainable solutions that can be adapted to different frameworks, adapted to different updates to frameworks. It's humans that create those, and it's humans that exchange information about how to maintain those. At this point, even though we are in a generative phase of AI, it'll still take a long time to build up to what they call superintelligence. And even with superintelligence, I want to go on record and make a statement that's going to shake a lot of people over the next 10 years. Superintelligence will still not be able to produce as much in terms of software as communities of open source technologists and engineers.
Interesting.
Well, yeah, that's I like that. So it means that we will still have our jobs in 10 years.
Definitely.
Another point I want to make, and I want to see if Gilles agree with it. Given the rigorous process of patenting, do you feel if a technology utility is patented, it's actually more versatile and more useful in the long term? Because if you look at a lot of open source projects, their maintainers would lose passion and stop updating, and sometimes it took a weird turn and it becomes an open source project that from very popular to nobody likes it anymore. But with a patent, it's more well defined and a name is tied to the project. Do companies consider these technologies more reliable?
They do. When you look at companies like Huawei, Samsung, Canon, they have products that we've been using for the last 4 to 5 decades. And each time they put a patent, it was a little increment improvement on their previous product. They are reliable. They have the history. And for those who want to learn how to use their products or solutions, it's easy to find them based on those patents. The patents themselves, they register what was made and created by humans in history at that time. And it just continues to grow and evolve. You can look back as far back as 1792 to when some of the first patents were made in the United States, and look at how they've just grown to become what we have today. I think even the shower head and the faucet, they have patents that can actually be looked up. Full design of the first sink, the first faucet, the first shower head, components and exactly what the components were used for, the physics behind it. So this is just ways of showing that's how reliable they are. Two centuries later, they're still here.
I said there's a rigorous process with patent. Let's deep dive into that. Can you tell us more about the patent process? Or should we start with what's your day-to-day like as a patent agent?
So the patent process is preparing the application, filing the application, and then prosecuting the application. So here's where the patent begins. Inventor conceives idea. Inventor takes the steps to build the idea, reduce the idea to something practical that people can use. So they have a prototype, they have something that they can use to now get rights. Next, they do their due diligence and then find somebody to represent them, or they can represent the idea themselves, meaning they can document the idea, the drawings, the diagrams for the idea, the specifications, the technical functions of the idea, and then also the claim for what they want as far as property.
Or they can hire someone. Who would be the someone they hire?
And that person that they hire is a law firm or a patent agent or patent attorney like me, for example. So let's say they take that option. They do hire me. I meet with the inventor. I discuss with them about their invention. They disclose to me what they're doing, document a summary. So usually I ask, what's the problem? What's the solution? The inventor will tell me what problems they found, and they'll say, well, one day they were thinking about just a simple way of doing something, and boom, they came across a solution. Okay, all right, their problem and solution. Now I go to them and I give them a claim for what I think their invention is. They look at the claim. If they agree, we then build out a 40-page document. It could be between 25 to 40 pages about everything that their invention represents.
Single space.
That's right. Okay, well, actually, we'll start the draft single space. We can get to 25 good pages single space. Then maybe I'll make it a page space and a half. That's a good one.
That's a serious question. Like, if I'm a client, I'm like, I paid $50K for this. Why is this double spaced?
But make sure you get as much as possible in this document. No white space. No.
Sorry, go ahead.
That's a good one. And now, so when this document is ready, it gets filed to the United States Patent and Trademark Office. It has the inventor's name, their address, all their information, and then the patent office will take 18 months to look over the documents and make sure everything is consistent. It actually takes 18 months for them to do that. And that's because
And they get examined by how many people from the patent office?
two people, technically, one examiner and their supervisor.
And how do they examine it? Is it solely based on the application, the documents, or do they also need to talk to the inventor themselves?
Solely based on the application. But the examiner can request to talk with the inventor too. Actually, inventors are enthusiastic. They like it when the examiner requests that discussion because now they can go into all their research papers and publications and just how they came up.
Well, but do examiners enjoy talking to the inventors? Like when you were an examiner, did you enjoy talking to the inventors?
Actually, when I was an examiner, I used to think to myself, okay, yikes, the inventor actually wants to talk to me. I enjoyed it. But at first, I will say I was hesitant because it hadn't never happened before.
Oh, so it's very
But it's
rare to talk to for examiner to talk to the inventors during the
it is
18 months.
so during that 18-month phase, it is rare. But I will say it is fun. When talking to the inventor, I actually got a more up close and personal understanding of what the inventor was doing and why they were doing it. If I hadn't talked to the inventor, I would just be looking at their invention and thinking about the inventor as just another person. When you actually have that conversation with the inventor, it makes you have a clearer picture of what they're doing. So now, for example, I can go and look for the competitors better because the inventor told me what field they are. And that's why, again, earlier in the conversation, I was asking about an inventor profile. So if you have an invention and you're enthusiastic about it, I'm going to your inventor profile to see all that I can find about the work that's done behind this invention. That's because me as an examiner, I had a chance to talk to one inventor personally. And when I did, approaching the conversation, I didn't know what to expect. But coming out of the conversation after 30 minutes, it was great. Got a lot more insight, a lot more understanding about their documents that they had written. And it also makes for a more effective process. Again, these are some of the rare, what's what I'm looking for? Some of the rare privileges that examiners get. But if not, most examiners, the mindset, 67% of the time, two-thirds of the time, they're looking to reject.
Oh, to a
That is
certain
a
of the time.
cold, hard truth that I must say about the USPTO.
And that is
Two-thirds of the
across all categories.
across all categories of technology, business processes, physics, their goal is to reject because there's so many inventions out there. We really have to make the difference between what is existing and what this new invention is doing.
Yeah. To be honest, one-third is higher than I thought. I expected higher rejection rate.
Some field of technologies are very strict. They have very high rejection rates. For example, software. Software tends to be a higher rejection rate. Databases, analytics, high rejection rate. But then there's other groups where, for example, mechanical systems that deal with combustions and air and airplanes and engines. It's harder to reject because you have a tangible structure. For example, if you have a full engine, you see how the engine is designed. You see where the air intake may come in, where the combustion chamber is, or where the pressure release is. It's harder to reject on something like that because the structure is right there in front of you. But overall, as an examiner, their goal is to show that the invention is useful, show that the invention is original. There's no competitors out there for it. And if there is competitors, ask the question to the inventor to see what makes them different from the competitors. Now, me, on the other end, during this process, I'm the agent facilitating for the inventor. So I'm negotiating with the USPTO and also negotiating with the inventor as a middleman to make sure that the inventor gets as much coverage as possible and the USPTO gets the best quality patent that they can have. So that's the goal of the agent. Now, other people who are in play here, there's the attorney who is looking at the law behind the decisions made by the USPTO. And they tend to have a higher weight of judgment on what the client should do in order to protect themselves legally. So where I understand the patent process, the lawyer understands the legal coverage and the legal protection for the inventor.
But that's usually after the patent is already done, right? So a lawyer will go in when there is an infringement or there's a litigation going on, or does the lawyers come in between the filing process as well?
The lawyer comes in between the filing process too. Because, and the reason why, let's take AI, for example. There's so many changes in what they consider compliant under 101. So for the United States Patent and Trademark Office, there's a section 101 that explains that abstract idea I was telling you about earlier. How do you prove that an invention is not done by the human mind, done by math calculations, or just a human activity. A lawyer has more updates about recent decisions made for other patents, and they can apply jurisprudence to better protect the inventor during that process.
Who hires the lawyer? Is it the inventor or is it you, the patent agent, hiring lawyers on your client's behalf?
The inventor hires a lawyer.
Okay.
And I think patent agent works at a law firm, right? So they hire the lawyer and the patent agent together, or would they be done separately ever?
That's right. The first one. So the inventor will find a law firm, and then the law firm will have agents and lawyers that work
working
on the
as a
invention.
team.
But the process, what makes it rigorous is sometimes you get multiple rejections. Sometimes you can get 3 to 6 different rejections on an invention. By the time it
You
gets
will file again and again?
yes, file, but it would be filed as responses and amendments.
It's still the same case.
Still the same invention. But now for the inventor, what makes it challenging for the inventor has to take that new information that they never knew about and really dig down and see where exactly does their idea have value. And a lot of inventors have that challenging situation, especially, let's say it's a startup invention. And then let's say 6G, hypothetically, new invention comes out. The inventor has a competitor, and they find out the competitor is Ericsson, Nokia. Actually, let's even go with Huawei. They find out their inventor is Huawei. Now, how are they going to show that what they do is different from Huawei's product? It's a hard question.
Yeah.
They have to really look at, again, what's their problem and what's their solution? What is Huawei's problem? What's Huawei's solution? How does theirs make a difference? And what step do they perform that Huawei could never have coverage over?
Gilles is really selling me on this patent process. Given all given all the AI startups right now, they really need to go through this process to really know if their product makes a difference. It's a rigorous process.
But AI is so new. Like in this space, Jill, although the patent office, the USPTO, is giving like directions or guidelines, is the patent process for AI products clear to you or like patent agents? Like for example, if I bring my invention to you as opposed to I bring my invention to a different patent agent, will I get like totally different responses?
You'll definitely get totally different responses. I'll tell you what, it's not as clear to me. Matter of fact, it's as clear as mud. I've been in this space for the last 14 years. And every time it just grows and changes. Sometimes they even change the decision.
Oh.
What do you mean they changed the decision?
In 2019, the decision on AI was one way. In 2024, they changed the decision again. And then now in 2025, the new director, John A. Squires, comes and they changed the decision on AI inventions again. It's
Wow.
they call it a very confusing space because right now the law is trying to keep up with inventors. The law is trying to keep up with technologists and engineers like yourselves because you're all brilliant. You know, you're all creating very unique solutions that the world has never seen. And the thing is, when you create a solution, you make it available in open source. An entire community of developers now knows about the solutions, and it's now creating and evolving the idea that you've created. So now plenty of other people have ways of being creative. They have ways of creating their own solutions based on what you've now made public. So the law, when it comes to the ideas for artificial intelligence, it's hard to make set decisions on what's going to be patentable and what won't be. It's still a very new space.
If there are new laws, do they make previous patent invalid or they state the decision stayed the same?
That's a great question. Sometimes, inevitably, there will be patents which were made invalid.
Oh,
So when the law changes, they have to now go back to the record of current patents and take some and make invalid or reassess them for the patentability.
oh, that's crazy. Yeah, when I first met Gilles, after talking to him, I went to a patent office webinar and I joined the webinar. They are recruiting. Given the current environment, a lot of Fed jobs are at risk. But I went to that webinar. They're hiring 11,000 patent examiners this year, 2025.
Wow.
So they definitely have a lot of demand. How do you take that? Where do you see the demand comes in? Is it all from AI or is it from somewhere else too?
Majority of it is AI, but there's also quantum, which is coming up.
Oh.
How about blockchain? Because you worked on blockchain before as well.
Blockchain is still consistent. There's no relative increase, but there is more blockchain inventions now too.
So if you're looking for a job, patent office is actually hiring and they need a lot of technologists to go through these patents. And like Jill said, even when there's a new law passing, they probably need examiners going through past patents as well.
And the benefit for them, the more examiners they have, the better, because they have more points of view from each examiner on how they're looking at the invention. So it helps them to actually make better legal decisions. But talking about emerging technologies too, we also have AR and VR. So again, augmented reality, virtual reality. The metaverse made an introduction back in 2021, 2022. But what we don't know is that there's still a lot of solutions being built in that metaverse space now. It's not as popular as it used to be, but development of virtual reality environments is still continuing. And then 3D printing, that's also, as far as manufacturing and those kind of systems, that's also another space that's growing and evolving. And then there was one more. Semiconductors, definitely. As far as improving the quality of the hardware, that's been a steady business for the last decade, and that's not going anywhere.
Yeah, it's booming again.
For this emergent technologies like quantum, blockchain, and AI you just mentioned, do they have a higher or lower rejection rate compared to other technologies?
I will say they have a lower rejection rate because there's not as many inventions out there that look like these inventions. Right now, we're establishing the first patents for those inventions. By first, I mean relatively the first 10,000 or so, first 10,000 patents.
I saw a
Good question.
I saw a chart. It was a line graph, and it just shows the number of patents related to AI just skyrocketed
Exploded.
in the past 2 years from both America and China.
And so just a trivia fact, there was an AI winter back in the 1980s, all the way up to the web boom. They stopped making intelligent agents and intelligent systems. That's what they used to call them, intelligent systems. And then right around 1999, 2000, that's where we started to now see the World Wide Web, stored information, hierarchically stored information that can be used to do analytics and gain further insights on it. And then from there, now they started realizing we have models that we can use to learn over this information and create more models. From 2002 to about 2016, that's where the first AI momentum started building up. And now companies are seeing practical use. They're seeing how they can apply it in industry. And it's led to that hockey stick that you're mentioning.
You mentioned like most of these utility patents are related to industries. What industries do AI patents usually work in?
The Internet of Things, industrial IoT spaces. There's also cybersecurity.
Do you see bigger incentives or bigger demand for patents from areas or industries that are heavily regulated?
Surprisingly, yes, because although they are regulated, they're seeing the benefit. And because they have structures in place, it's easy for them to look at what they're doing now and see how to incorporate AI within that while still maintaining those regulations. That's one of the big challenges over the next 3 years.
How much is it to file a patent actually? Because I can see a lot of big pharmaceutical companies and manufacturing company, they will have a patent department even inside their own company. So I consider it an expensive endeavor to keep patenting stuff. How much is it to patent something?
Are we asking about from the beginning when it's filed through to the end when it's allowed?
Yeah.
Okay, for small corporations, small companies, between 10,000 to 15,000. Larger companies, they budget for full portfolios, full collections of patents. So one patent for them could be up to 22,500.
So that's including the staff they have. They have internal patent agent, lawyers, or is it just for filing?
That's including the staff that they have. Are we just asking about filing without
yeah,
if
I'm to like use ChatGPT to do it all by myself,
okay.
How much would it be? I'm sure people try to do that.
Okay, much less. Okay, so in that case, it would be 5,000, about 5,000 to 7,000.
Still quite a lot for me to consider doing it. Yeah.
I wouldn't do it myself. With the changing directions from patent office, with the changing laws, I'd rather have someone do it for me.
The tricky thing now is going to be it's going to be tough for somebody to look at your patent application because you might have somebody from another field looking at your patent application. The USPTO, they just made an incentive where people from any field can look at a different field and examine and make a decision. It's not going to be as easy. So example, if you have a AI invention that you create, you might have somebody who is a physics specialist looking at that AI invention. They may not be familiar with AI, but they'll do their best based on the examining procedure, give you an assessment. More than likely, it may lead to that 1 out of 3, that 2 out of 3 rejections.
Speaking of that, what is your background, Joe?
Computer engineering and computer science.
Oh, so
but you had, when you were working as an examiner, you had to also examine combustion engine and other types of patents, right?
Yeah, sure did. One thing I learned is just letting go of who I identify as when examining those difficult cases. Because yes, I could be focused on computer engineering, computer science, but if they gave me a combustion engine, first thing I have to realize is accept I do not understand combustion engines at the moment. I'm going to make myself familiar with some articles, some research publications. I might be a Google Scholar for the next 2 hours. I might have to look at some YouTube videos for examples. Combustion 101. How does it work? And then after maybe getting some fundamentals, 3 or 4 days later, now I can actually start working on this competently.
You must have learned a lot during your time there.
Yeah, I learned a lot, but the main thing I learned is where there's a will, there's a way.
What's the most interesting topic you had to dive into? I'm more asking about a field that you're not familiar with, but since you got the case, you had to learn about it.
Okay, so in that case, there was one for measuring for dyspnea, measuring for labored breathing. There's a helmet that they put on the patient, and the helmet can read brain waves to tell whether a person is awake or whether a person is going into a deep subconscious sleep. There are people who they have sleep problems, and sometimes the sleep problems can cause them to have heavy labored breathing. This is actually a project associated with a medical institute. So for the research, I have to first understand the physics behind how they read brain waves, and then after that, understand what brain waves are associated with, trouble sleeping. Then based on that, determine whether the person is approaching that state of dyspnea or not. And up until that point, I had never heard of the word dyspnea. I know what apnea is, but working in medicine and working in that field, that was a tricky concept, like learning how electronics tie to the functions of the body. And again, just some words that I've never been familiar with.
So did this invention got a patent or rejected?
As of now, it's still rejected.
Oh, still rejected.
And they actually have technical documents from professors who proved how this works and why it's original. And even with those supporting documents, the USPTO is still keeping it rejected right now. It's on the way to at this point, there are some examiners who don't like to, they have trouble accepting cases. They have trouble approving patents. Examiners who consistently reject, those cases stay alive. They continue staying in their collection of cases they need to address. So the more they reject, the more the rejection pile increases. If they're not allowing, they have to continue working on the rejection pile while taking on new inventions. It gives them less time to make decisions on the cases that are in the rejecting pile.
So do they just keep rejecting those, or do they just pass them to get them out of the queue? It sounds like they just keep rejecting them.
Exactly.
Just in the back pile.
That's one of the tricky parts, especially when people want to get promoted at the USPTO. Because I could say I started out on that route too when I was first at the USPTO. The first 2 years I was just rejecting a lot of things. And then one day my supervisor came and said, you're going to have to allow some of these at some point. And I asked him why. And he said, because if you keep rejecting, then you have less time to look at the new ones because you have to keep addressing the rejected ones. So you have to learn to give up some rope and let the cases get allowed and find ways to get the cases allowed. Negotiate with the inventors, understand who the inventors are. When you talk to the attorneys, learn that art of communicating and negotiating, finding a good middle.
Would you say the patent process can be very subjective?
Yes, it is. Okay, I see it from the lens of value. The asset itself, when we decide we're going to grant the right to an inventor, what was valuable about that invention that they got the right granted to them? That decision, laws involved, but ultimately we have to look at all the other inventions that exist and everything that's in history and make a decision about why this person gets an ownership in history too. That kind of decision, it can be more subjective than objective.
It's a weird analogy, but it's kind of like immigration.
Like
immigration examiner. Yeah.
Which visa officer you get.
Yeah, which visa officer, or at the very end when you are doing that final immigration interview, it's very subjective.
Yeah. As somebody who came from Cameroon and came to this country, I could say definitely understand that process. had a lot of help from people who were here in the United States in order to help give us information for applying and getting here to the United States. But I think that's one thing that this country has that again it makes a difference for those who can come here and again build their life. There's a structure and there's a structure to how things are done, and they appreciate when people follow that structure and do the right things, give the right documents, make the right case in order to have a certain right, whether it's a right to ownership or right to citizenship.
When you were talking about the examiner's job, I also felt that too. Although a lot of patents get rejected and there's this long process to get anything done, but I also hear a lot of respect from the examiners to innovation, because if they don't have the standard, then 100% of patents will get passed and innovation will not be there.
I mean, everybody can get a patent. There would be no real
no
share.
value. Yeah.
Yeah. But speaking of that, each person has their interest. The USPTO wants to make sure they have patents that when they give it to the public, everybody can see why each one is unique. And they really go down in history for that particular point in time. The law firm wants to make sure they keep their client's business. They want to make sure they can get one invention for the client, and then maybe the client will recommend them to other people and get more inventions. The inventor, that is their career. That's what they do. They invent. Most inventors, they do it from a place of craftsmanship. There's a passion behind what they do. They wake up, they have ideas, and they want to see which ideas can make the most impact on society. It's the way they see the world. It's the way they live. Most inventors who continue, they eventually build a system for how they invent things. They want to see how many can they possibly have ownership on? Because ownership for each invention is 20 years. If they can carry this out for the rest of their life, there are some people who can invent for the next 20 years and have an entire career of 40 years of property covered under their name. Some that they buy, some they sell, some they license, but that is where that is where they make their living.
I think inventor can be addictive, and they become serial inventor after that. Yeah, I once met an old guy, and then he told me he has 15 patents. And once you figure out how to do it, and you love inventing, and he just keeps doing it until he's already very old, and I believe he's still thinking about new ideas all the time.
I find some more like traditional engineering or engineers, many of them have patents. As compared to us in software engineering, very few of us have patents.
Compared to other fields, software engineering is one of the newer fields, relatively.
I see more individuals with patents from traditional engineering field as compared to software engineers. So for example, I have friends who are in chemical engineering, and they work at companies like Dolls, and they have several patents after, say, 3-4 years working at the company. But for us engineers in software engineering, I don't think I know anyone in this field with a patent.
I wonder, talking to people, are there any challenges that come up? Do they mention any challenges
in software engineering
that they have, yes, with making or establishing patents?
I think it's more about the idea wouldn't come up. If they have an idea, they either just do it and solve the problem, or they just start selling them right away.
And also the time investment, like 18 months. 18 months for software engineers is like forever. People don't commit to an 18-month project easily.
Is 18 months non-negotiable?
Actually, no. There's a faster way.
Oh, fast track.
Yeah, there's a fast track. Exactly. That is what it's called. A fast track application.
If you pay more money.
That's right.
Just like Visa.
They can get it done in the next 6 months, yes. And actually companies like Oracle and some of your large database storage companies, they love that fast track.
Oracle is famous for making money out of their patent infringement, right?
Oh, yes, they are. Because when we look at all these companies that are creating data center implementations, they use a lot of storage techniques, which Oracle already has ownership to. For Oracle, they built a lot of that in early 90s to early 2000s. That's when they built a lot of their collection. And now they're using that. Okay, so at this point, we're 2025. They have to rely more on what they have from 2000 to 2010. But this is part of their strategy. With patents, there's actually 2 strategies people can use for when they have ownership. There's a defensive strategy and an offensive strategy. A defensive strategy is one where they collect as much territory as possible, and then they defend by suing anybody who infringes on their territory. An offensive strategy is where people create the patent, establish it, and then now they go against others who are in that field and actually seek to attack them on
Oh,
purpose in order to push the issue and gain just a little bit more territory and some money for large corporations. So Oracle is famously known for using that defensive strategy.
I heard it has become one of the largest income stream for Oracle.
And this is where a lot of the big negotiations happen, having that kind of leverage and bring in those amounts of funds in every single year.
Why did you, because you say you have computer engineering background, back when you just finished college, why did you decide to join the patent office instead of becoming just a software engineer? Because at the time, I believe tech jobs are really hot too.
Yeah, that was 2010.
That's right. I was focused more on the ideas. I enjoyed the part where we were brainstorming and looking for different ways to implement a solution. By the time we got into the solution, that was what usually kept me pushing through the project. The original ideas that we talked about, and the more we got into implementation, the more I thought about those original ideas. The second reason, I read a Time magazine about Albert Einstein, and I found out that he started as a patent examiner for 7 years,
Oh, right, right.
Really?
looking at different aspects of physics and this is where he built a lot of his understandings for the theories he created later.
The more I learn about it, I think it's perfect for entry-level engineering job because you get exposed to so many different things all at once.
Was it a popular career choice back then of becoming a patent examiner or a career in patent?
In 2010, no. People knew about the office, they knew about the government, but when they looked for jobs, they usually went for more of the clearance jobs or top secret clearance jobs.
Oh,
Top secret clearance job.
Those that focus more on military defense and government, large scale government projects.
So
the darker
so-
side of the government.
so
Right. Or you could say that.
yeah, so it's very interesting because Jill went to Virginia Tech, right? The career choice around Virginia seems to be more related to government and public sectors. If you ask new grads from West Coast who study computer engineering, they will for sure go to private companies, tech companies. Is that specific to Virginia Tech or just like the region in general?
Say the region in general, DC, Maryland as well. We have tech companies here too, but it's either tech companies or security clearance kind of work for the government. But actually, yeah, I guess I was looking at more of the DC, DMV area when I was answering that question. When we look in general, though, a lot of people did not focus on the USPTO because the work there, it was patent work. It's not really related to engineering, but it does involve engineering. Only certain people know that engineers are actually some of the main people who become inventors because that system that we use for building, developing, maintaining life cycles, this is what it takes to actually invent and grow solutions that we invent. I was one of the few who learned about this. It was because one of my friends from college, he worked at the USPTO. So one day he told me about the work that he does, and I was curious. I went and did research on what the agency does, and it sounded like something that I'd be interested in. I did the interview. It went very well, to my surprise. And after that, it was just off to the races. 10 years, and I never looked back.
I have a very random thought.
Okay, surprise me.
Earlier we said that the patent process can be very subjective, up to the patent examiner to decide. If you, say, worked at the patent office for a few years and left and became an inventor yourself, your experience at the patent office will make it easier for yourself to patent your invention. Has anyone taken that path?
And actually become their own inventor? Yes, somebody has. I know somebody who they created one of the first dusters, one of the first dusters to move on the floor by itself. You know how you have to brush and you have a duster that you use to brush the dust off the floor. They created one that would actually move by itself.
Okay.
And be able to scan the floor as it moved around.
Yeah, I wonder if it was easier for this person to get the patent if he did not work at the patent office.
You know, when he was going through the process, he told me about he told me he got 2 rejections, and even then, he was still complaining. He was like, I know what an examiner thinks. If I made the rejection, I would have made the same. I would have made that rejection. Come on. So he did explain about some of the challenges he went through, but he got it, and he got the patent in 24 months, if I remember.
Oh, okay. Not bad.
He got it very fast. A lot of people who work at the USPTO, when they eventually go into other spaces, whether they become inventors or become somebody giving an IP services or giving some form of IP service, they're actually very good at what they do because they understand the functions of the agency. And the agency appreciates people who understand that perspective too. Me as a former examiner, when I talk to them about patents, it's easy to guide the conversation in ways that are favorable to the inventor and also incentivize them too. Sometimes the examiners get bonuses, they get quarterly bonuses and yearly bonuses.
Ah,
So at certain points of the year, I can tell them, hey, October is coming up. It's the end of the fiscal year.
oh, you can time it.
Talk to them at the right time and talk nicely. Can make some things happen. I do need to come back to a question that Amy asked me earlier. Actually, no, I think it was you, Stella. You asked me about work as a patent agent. So, and what I do on a day-to-day. Right now, a lot of my work is investigative, doing a lot of investigation on these new changes in the AI patent laws. And then I also do webinars on licensing. So every day I start the day by doing one webinar or some investigation work. Then I take my breakfast. My favorite breakfast is a muffin. It's called the Better Morning Muffin.
Better morning.
It has
Nice.
coconuts, carrots, and some multigrains. Very good on fiber. After that, drink some green tea and then start working on inventions. Every day, 3 inventions I look at. One that has a rejection, because majority of my inventions, they come in with a rejection. We have to make a decision. Another one that I have to talk to an inventor about. So that's the second one. And then the third one is one that I have to talk to the USPTO about to negotiate for possible issuance. So between 10 a.m. to 4 p.m., those are the 3 inventions I'm working on. And in between time, I'm probably stopping by coworkers to discuss about some new wins we've had, some challenges that we've had during the week, and also talking about life too. How was the weekend? How was the holidays? How's the family doing? Those kind of things. And finally, keeping an eye out for possible conferences. There's conferences where we can all go network, and also by networking, like, so for example, there's the nonprofit that I was telling Stella about 2 weeks ago. It's possible to find new clients and also possible to find people who would be interested in joining the patent field and taking the patent bar exam.
When did you take the patent bar exam? Because you made the career switch from a patent examiner to patent agent. Patent examiner works for USPTO and patent agent works for law firms. Why did you want to make that switch and how did you do it?
So to do it, I took the exam while I was at the USPTO, actually. This was back in 2017. So I took the exam because regardless of whether I stayed an examiner or went to become an agent, I knew that exam would be important. The way the exam works is an 80% passing rate, and the focus is on all the rules about patent law and for the procedure. As an examiner, what's the next best action an examiner should take? As an agent, what's the next best action an agent should take? Understanding what are the best decisions for each side is what makes a person ready to become an agent. So I took that exam in 2017, and then in 2022, I was actually getting ready to get promoted to one of the higher ranks of examiner. And then one of my friends at a law firm, he gave me an opportunity to work on AI inventions at that law firm. And at the time, I told him I was comfortable being an examiner. Like, I just want to stay being an examiner, get to the higher ranks, eventually maybe supervisor, director one day. That's my career track. Then he gave me another opportunity. He said, we have some AI companies, big companies that are looking to quadruple their stock price in the next year. If you can work on that portfolio and help establish those patents, I think you'll like this role. When he told me that, I said, I'm sold. I'm good to go.
Did it quadruple?
Yes, it did quadruple.
Wow.
I'm not going to name the clients, but I can tell you, when you look at their stock prices from back what they were in 2022 and what they became in 2023, you'll see the growth.
How much did your patent work play into it?
An important part, because a lot of the negotiations, there was a lot of rejection that company was getting that year.
Mm-hmm.
And I believe there's 4 of those inventions where I was able to make the argument and bring it to allowance right away. And at that time, because I had taken the patent bar, they were able to use that information and promote me right away to patent agent.
Do you need any pre-qualification for taking the bar exam?
Anyone can take the exam.
Oh, you need a STEM degree.
So let me clarify that. Actually, yes, Amy's right. Any STEM degree person can take the exam. For people who are STEM majors and looking to become patent agents, 3 things that do help when transitioning to this role, and especially with the patent bar too. The first is having a good understanding and being self-driven within your STEM field. So keeping up to date with news in that field, keeping up to date with companies, what the companies are doing. The second thing, you do have to have some business acumen. So a person does need to know how the business works, how they generate value, and how bringing them on as a client and taking on their inventions would add value to what they do. And then the third one would be negotiation, communicating, negotiating, and working within those gray areas. A lot of the negotiations happen in those gray areas. There's no absolute black or white decision. looking at things from perspective of absolutes, that's what we're trained to do as engineers and technologists. Within the patent world, things are done from a negotiation standpoint. There are points in the middle where you can find leverage and use the gray area to bring things to a favorable outcome for everyone. So yeah, learning how to see things as not necessary and just enough to make things happen, that's where the real work is.
Self-driven business acumen, negotiation skills. Those are skills needed for a product manager as well.
Definitely is.
So very much similar.
I was a product manager for 9 months, and the CEO, she was the one who taught me about the importance of that. Oh, actually, there's also one more too. Being okay with imposter syndrome. When I transitioned and became a patent agent, I had imposter syndrome for a year and a half. It's similar work, but it's something I've never done before. To make it through that phase, a lot of what drove me was enthusiasm for the kind of work. One thing that I see with anything dealing with inventions or creations or inspiration, enthusiasm is a space where a lot of things can happen very fast. When you see the opportunities, you stay optimistic about it, and you believe in what can happen. During that time, I was struggling with imposter syndrome. And, it's interesting. One of my coworkers from my first firm, he told me every time I saw you, you're just so upbeat and you're just so motivated and just always ready to get after it. And I told him, thank you, because deep down, I was actually having a lot of imposter syndrome with the work.
What was the cause of the imposter syndrome? Is it because you work with a lot of lawyers or are the cases really difficult?
The fact that I still identified as an examiner, I couldn't transition to identify as an agent yet. So coming into that new identity and then also working on AI inventions that were a lot more improved every single year, that was a big challenge. I hadn't found myself when I first started. It took 6 months to get stable and get a steady workflow.
You also mentioned self-driven. How do you keep up with all AI technologies? Just like us, we have to stay on top of things all the time. How do you do it?
Look at over every single year, what were the spaces in AI that had the most inventions? From there, finding Udacity courses, Coursera courses, even some coding platforms. They have coding challenges related to those particular spaces. Every week, I'll take 2 days and just do some research, work on a course, or continue improving my coding skills.
Your coding skills? Wow, you still code now?
Yeah, I still do. I'm a hobbyist developer. Actually, coding makes it easier to write as far as legal work, because knowing how to write things precisely and write technical details, it's very much like writing pseudocode, looking over logic.
Wow, this is a great job. You're paid to learn new things all the time.
Patent agent is definitely one of the, because I like looking at different jobs in my spare time, which is a weird hobby. I like looking at niche jobs, and patent agent is definitely one of the more interesting find. And we've been talking about patent and technology all this time. Other than patent, what do you do in your spare time?
So in my spare time, I like to go hiking, like to mix music. And I've also been getting into the fashion space too. So finding fashion shows to attend, collections, talking to designers, they're a different kind of creative. I enjoy talking to people who are creative in different ways just to know what their process is like. It helps me also refine my process when I'm talking to inventors.
I didn't know you can just find fashion shows to go to. I
Yeah.
thought you need to be invited.
Yeah, I thought it's invitation only.
So they are invitation only, but of course, it starts with networking events though. So going to networking events in the cities, usually the major cities, your Los Angeles, let's see where else, maybe a Houston or a Dallas, Washington, D.C., New York, Miami. So just going to networking events there and also meeting people. And when I meet them, usually I tell them that I'm in the IP field. So there are opportunities that we can collaborate on later on, not for patents, but maybe for branding.
What type of fashion shows do you go to?
Let's see, there's a DC Couture collection. For DC, we have an international collection show that we do. So it's a show where people from other countries come and present their designs in DC. So they could be from Ukraine, Saudi Arabia, Dubai, Ghana, Australia. They actually do a full show here in DC, 2 to 3 hours. They show the men's line, they show the women's line, and then they also have photo shoots after with the people who attended the show. And then there's also New York Fashion Week. That's always a big one. And then for Miami in the summer, they have their Fashion Week too. So different shows, different podiums, but definitely a lot of networking.
Is this just a hobby for you, or do you also look into if there's any like side business opportunities in fashion industry? Not
For me,
necessarily patent related.
exactly, not patent related. But when it comes to designers, especially the male designers and their concepts, I just think there's an opportunity there for business in the future. So maybe after transitioning from patents, might be working with some fashion designers to make some new couture or something.
That would be so cool. We definitely have never been to fashion show. What do you wear to fashion show? Because we see stars, they get sponsored. They
Yeah,
have
like high-end
they have
clothes.
high-end dresses and stuff. But for the rest of the attendees, what do you wear to fashion show?
So usually suits. I like brown colors. I like blue colors, the emerald green too. So usually I'll do a suit, a blazer, pants. Want to be very fancy, a vest or waistcoats underneath. And if I really want to get out my element, I'll do a robe, like a blazer
Ooh.
robe.
Oh, yeah, that looks really nice. Yeah.
Not like a trench coat, but more like a longer robe that's still
Mm.
buttoned and well patterned, well embroidered.
Hmm.
Actually, a lot of those, it reminds me of the African attires that we wear in
Mm-hmm.
Central Africa. I'll say those are my go-tos. And most people
Mm.
who are not attendees, they tend to find different color schemes that they match with. That's a lot of ways to be creative. So there was a point where I was an event producer. I used to produce for social gatherings. There was one where we had a sponsorship with one of the airlines, and we made a contest. Everybody could show what their dream vacation would be. Imagine a dream vacation. And whichever group had the best dream vacation, they won tickets to that destination. So I used to produce events like that. And recently I started getting into the fashion space, like how they produce the events, the way the aesthetic is designed, and talking to the producers there and talking to the designers. For me, the benefit I see now is learning about that creative process, learning about
Mm-hmm.
how different people think and imagine things, tapping into that creative mind. It's something unique that most people don't get to do that on a day to day. Talking to
Yeah.
somebody who does that all the time, it's a different experience. But we'll see. Yeah, the next 2 or 3 years, it could turn into an actual concept beyond a hobby.
Yeah. What business opportunities do you see in the fashion space? Are you inspired to become a designer yourself, or do you want to become an event planner in this space?
I see event planning and also having events where it's more international, like those
Mm.
international couture collections, like really being able to showcase different products, different clothings from different areas of the world.
That is important.
And
Yeah.
for me, that motivation, it comes from when I was younger. Growing up, I was raised in Cameroon, Central Africa, but I lived in 7 different countries before
Oh,
coming to the United States.
what
So it
were
was like
those countries?
there was Niger, there was
Mhm.
Togo, Burkina Faso, and then also traveled up to Belgium. And
You live in
so
Burkina Faso? That's cool.
very good people there, very nice people actually. And a lot of that was because my father used to work for the embassy, for the US embassy.
Mm.
So every time they would move him to a new embassy, we would move as a family with him. Eventually came to the United States, and after that stayed in the United States. But traveling to all these countries, getting to see all these cultures within 4 to 5 years, it helped me to see and understand the world better too. It definitely gave me ideas for just understanding cultures and ways to bring different cultures together.
Gio is very multifaceted because he works with lawyer all day, patent examiners all day, and now he's telling us about all his designer friends. What a life you have. When I was little, I wanted to be the daughter of an ambassador. I thought that's the best thing ever. First, you're sponsored by country, and everybody respect your family there, and you get to live in different places in a short term.
And it's an awesome experience because you get to meet a lot of dignitaries from each country too, to the point where, when they know when you know their last name and they know your last name, now, no matter where else you go, these are people that you can call to, you can refer to at any point, no matter where you go in life. I would say it is a unique experience. It's something that I'm very appreciative for.
Finally, Jill actually wants to help more people get into a patent career. Do you want to tell us more about the new offering you have, the new program you're running?
Yes, sure. I have a program I run called Patent Bar On Demand. So for engineers and technologists who are interested in transitioning to patent work, I can help prepare them for the patent bar exam. I can also give them a blueprint for what they can expect to work on in their field, their specific engineering field, or even their particular technology. And for that, I make it a 3 to 6 month process. So when they do transition and they do talk to recruiters and get hired, it makes that process more seamless.
How do people find you?
So I have a Calendly link
which we
where they
will
can,
share.
which we will share. And then I also have a website, www.gillesraoul.com, and I have a LinkedIn profile where you can follow me or connect with me.
Thank you, Jill, for teaching us about the patent world today. A lot of our audience are probably open source proponents, but I don't know if you haven't listened to this episode, if you change your mind and thinking about patenting your technology now. But I learned a lot today, and I hope you guys enjoy it. We hope to do more English episodes. This is our third one. And please follow us on the Substack. We run a Substack newsletter called The Cocoons by Stella and Amy. Feel free to subscribe and see you next time.
Bye-bye.
Bye-bye.